My name is E. David Smith, and I'm an attorney. I'm admitted in 3 states, New York, New Jersey, and Georgia. And I have an international practice. I represent clients from around the world, including Europe, South America, Middle East. And I represent clients' interests in the Far East also, and Australia. And we come across a wide variety of situations. We're going to discuss some of the situations that we come across. Now, the first thing I must do, and you should know in any type of speaking situation or attendee, is turn off your cell phone. And it's very interesting. Someone explained this to me one time. He said, the worst thing that you could do in any meeting is to answer your cell phone, because every business deal is based on relationships. And whenever you answer your cell phone, you're really interrupting the relationship between you and the person that's right there. And what I find, he said, unless your wife is in labor, don't answer the phone. And it's really interesting, because I noticed one time I did that, answer the phone, I just saw how the energy around this table where we were making a pitch to a company just shifted, because I wasn't even this guy. I had my business partner next to me. He was doing all the talking, and I answered the cell phone, but it really shifted the energy. And I think that one of the greatest lines is when someone's in a meeting and he picks up the cell phone and he says, sorry, Shlomo, I can't talk right now, I'll call you back. Well, that's what voicemail's for. Why are you interrupting a conversation to tell someone you can't talk? And it says that it takes 20 minutes to be able to focus on anything. To get yourself back into focus, it takes 20 minutes. So to rebuild the energy that a person has in a discussion or a thought process or interaction or relationship takes 20 minutes. So that's a good lesson to remember in business and also at home. If you're having a discussion with your wife, if you check your cell phone, you're basically have to start from scratch, and you're 20 minutes behind. My first question to you is, before we start non-disclosure agreements. Now, everyone knows what a non-disclosure agreement is. As you signed it? Thanks. So my first question to you would be, how much do you think you'd be willing to spend in terms of money, United States dollars, to have someone prepare for you a non-disclosure agreement?
Depends on the project.
Okay, $100. $100? You'd just pay $100?
No.
No? Well, how much would you pay? $10?
Pay zero.
Zero. You wouldn't pay. You would go online and get a free form.
I have a friend.
A friend. Okay. How many people would pay at $10 for a non-disclosure agreement? Okay. How many would pay $100? You're not putting your hand up. Okay.
I think that's what I would need. I would feel not too comfortable paying someone just $100 to do an NDA.
Okay. How many would pay $500?
I would pay almost anything for a good one.
Almost anything. How many pay $1,000? Okay. Here's a good. Some people putting up their hands over here. 5,000? Okay. So it's I wanted to start with this survey because we don't realize how complicated a non-disclosure agreement is. And I get calls all the time. Someone says, I got this idea, like you do, and I don't want people to run away with it. And you prepare a non-disclosure agreement. Well, I started asking them all kinds of questions. What's the deal about? Well, isn't this just a simple thing? Can't I just get a form off Forms Online, $10? And the answer is yes. But the fact of the matter is, just the time alone to understand what your transaction is going to take an hour of my time. And if I'm charging $550 an hour, which is my rate, then already just to hear your story, it's $550. Now, if I'm going to have someone really develop this non-disclosure agreement, one of my associates, and make sure it's right, it could take another hour. Then we have, what does the other side have to say about it? And it could take another hour or two of negotiations, discussing with you what the terms mean. Then what happens if we reach an impasse and we can't reach an agreement with the other side? And then we've got to discuss, what do we do? Do we go ahead with the deal or don't go ahead with the deal? Do we insist on the NDA, or are we willing to go ahead without an NDA? So it could rapidly escalate into the thousands of dollars. Now, point I want to make about the money is this is really important, because I'm going to tell you a lot of things that they don't teach in law school, and it's just from experience. There's no classes on NDAs, but NDAs is a really narrow aspect of contract law, but it's really very, very essential, because at the beginning of your relationship with the other party, and not only do you get to protect yourself or make sure you're also offering mutuality perhaps to protect the other side if you're receiving the information, but you also get to see who you're dealing with. Because based on the type of things that they refuse to sign or insist that you sign, you could start to see how the relationship is going to develop and whether you want to go into any further business with this person. So it's an opportunity for you. So here's the basic principle. You can get an NDA online, and in fact, here's a form if you want to pass this around. This is a basic non-disclosure agreement that you could probably get from anywhere. You could probably get it at Staples. You could probably write it yourself, and you could probably pay $10 for that online. But my point I want to make to you is the only reason that you would want to spend $10 on NDA is if your entire business investment is less than $50. If you only have $50 at stake, then why spend more than $10? But if you're investing your time, if you're investing your money, your inventive ideas, your heartache, you're telling your wife I'm busy at work, and meanwhile you're just giving away free ideas to people, you're not really building much of a business future and a Parnassa future for yourself. So you really have got to be careful about how you're going to sign a non-disclosure agreement. So like you said, so wisely, it depends what's at stake. If you have a multi-billion-dollar idea, then you're not going to move without a non-disclosure agreement, and you would pay any amount of money for a non-disclosure agreement because, I think you said any amount of money, because you're protecting something that's really, really critical. And I was the lawyer for the Shark Tank at the Parnass Expo, and one of the companies that presented was a company, he got up there to raise this money, and he wouldn't even disclose what the idea was, some very vague thing. He wouldn't tell anyone how it worked. It was about a box that somehow you put the vegetables through it and they come out without bugs. And he had all these sophisticated investors on the stage, and he refused to give any details. And it was a very wise move. And the funny thing was that he got a pledge for more money than anyone else. All the other inventors who told everything that they were going to do, they got less. He was super secretive, and he showed his sophistication because he knew that if he told anyone what the secret formula was or how it worked, without a proper non-disclosure agreement, he was losing the possibility of a tremendous business, and he got commitments there of $500,000 just from hearing about a box that you put vegetables through, and there's no more bugs. I don't know how it works, and I don't know if anyone knows how. Maybe, I presume he does, but it sounded. I was thinking to myself, I think this guy's making such a mistake. No one's going to invest in this guy. He won't tell anyone what it is. I was sitting there commenting to another person sitting next to me. One of my associates was sitting on the other side. We're talking about this while this show was going on. It's like, this guy's out of his mind. He's giving so little details. No one's going to invest in a guy with a box that can't tell you what the box looks like or what's in the box or how it works. But the funny thing was, I was wrong. The investors, who were the ones with the money, they were willing to put up $500,000 subject to future due diligence just on the basis of his presentation. So the other thing is, the same question is now someone presents you with a non-disclosure agreement, right? So that's what happened right here. And I want to talk about what just happened because again, what's at stake? Now, you all received this non-disclosure agreement. Now, how much would you pay someone to review this non-disclosure agreement before you signed it? Okay, $10, $100, $500? I would suggest it'd be worth your spending $1 million to have someone sign this non-disclosure agreement because what you don't realize is what you signed away in this agreement. Okay, first of all, you didn't check who the parties are. So at the beginning it says there's a company called Legal Presentations International. Okay? Now, maybe there is such a company, but I don't know anything about them. You also signed away, and don't worry, after you could decide whether you want to continue with this agreement or not. I'll give you a chance to take them back. But you also signed that anything I say is confidential, right? Okay. And not only that, but you are willing to maintain the confidence of the fact of the presentation, the timing, and the identity of the presenter. Okay, now someone pointed out who read that, he said, well, it's public information. But what this means is you cannot go home and tell your wife that where you were, at what time, and who you heard speaking. That's what this says right here. If you go home and tell your wife who you heard speaking about what subject, at what time, and where, you're in violation of this non-disclosure agreement. And theoretically, Legal Presentations International could sue you for violating that agreement. Now, maybe they won't know what you say to your wife, but if you go out on Facebook and say, I heard a great presentation from E. David Smith on NDAs, well, Legal Presentations International might be watching Facebook for people who are violating this non-disclosure agreement. Now, the other thing that you signed away is not only that you can't say it, but you have to restrict the access to this information. Everything I'm going to say is covered by this non-disclosure agreement. And you also can't tell anyone you're going to pass the information on to, and your employees or contractors or third parties have to also sign the same non-disclosure agreement. Okay? You probably weren't aware of that. It also says that you, or the receiving party, further agrees to assign all rights and all derivative ideas and concepts to the disclosing party, and all financial benefits of any ideas disclosed by the disclosing party to the receiving party. So that means that any idea that you take that I give to you tonight, you owe to me all the, or Legal Presentations International, all the benefits of anything you hear tonight and any ideas that you have that are spawned by what I said. In addition, you're also signing over. I was inspired by all these stories about the Baal Shem Tov and these different mices where the guy goes along and says, I want your Olam Haba. You know, I want to buy. So I decided, how could I get you all to give me your Olam Haba? Well, that's what it says over here. It says, you're giving over all financial benefits of any ideas. That's financial, including benefits accrued, whether defined or undefined, tangible or intangible, from any source to the receiving party in this and any other world, now and hereinafter conceived. Okay? So any benefits you get from anything you do in your life, whether it's tangible or intangible, in this world or the next, you've now given over to by signing this over here. Okay? Now, you probably, none of you, I mean, one person, you didn't sign, right?
Correct.
Okay. He didn't sign, and that was part of what I wanted to show you. The guy didn't sign. Now, the thing is that you don't know. Like, I could have sent him out of the room, right? And he would have had to figure out whether he wants to sign or not, because the fact of the matter is, you're all intelligent guys, and you understand English, and most of you signed except for one person, right? Because what's going on? You're feeling pressure. I'm telling you I'm not going to proceed. You're not going to walk out of here. There's social pressure. There's pressure from what's going on. And you're
the presenter.
I'm the presenter.
For this topic, and they feel like
yeah, right.
You're not going to enforce it.
So you just gave away all your rights to everything that you could ever possibly acquire in this world. So how much was it worth to have someone read this NDA?
You didn't check what you wrote on the back.
Okay, well maybe you wrote some.
Isn't there a rule about some NDA being too broad?
Okay, we'll get yes. First of all, most people actually signed it with all their information.
No, you don't know that. You didn't check our IDs.
Okay, that's a separate issue. But the point is, I'm not here to enforce this agreement. But unless someone wants to sell these to legal
It's not notarized.
presentation. So notarization doesn't mean that's just for certain documents. This is a legally binding document.
One reason we here, I'm involved with the investment company, and they just finished a whole lawsuit since 2001, and it was because the identity of how they signed it was what they were arguing in court. Whether that corporation was of the U.S. or of another country, and they had a branch, and that's how they were arguing to get out of it, was the identity.
Okay, but that's after the fact. You understand?
But when they violated the NDA, and then they went to court.
Right. So that's what I'm going to talk about, because you don't know who Legal Presentations International is, and Legal Presentations International doesn't know who the receiving party is, right? So this is an introduction, and in case anyone feels uncomfortable, I will be happy to tear these up. But unless you want to all read them back to yourselves to see what you signed, but this is what happens every day. So we're talking about a non-disclosure agreement, and you think it's so simple, but we're going to see some really great examples over here of some of the things that you have to watch out for. So I want to talk to you a little bit more about non-disclosure agreements in general, and then we're going to go through the terms of an agreement and together, and then we'll look at some more complicated samples on the screen, technology permitting. So there's no such thing as a one-size-fits-all NDA. Okay, so people say, how complicated it is to do an NDA. And this agreement, here's what I did, is I took this, the non-disclosure agreement which was passed around, the one that says basic, what does it say on the top here? Basic non-disclosure agreement. That's what I took and made this one that you signed out of, okay? So even to make the simple changes I knew, was making, and I only did it in a way that would be sufficient to get through this experiment, but that took me time, okay? I had to think about how to put it in a way that you wouldn't notice in big bold letters what you were signing away, but yet could be clear enough that it would be enforceable exactly what you are signing away, right? So that takes a lot of time, but there's no such thing as a simple non-disclosure agreement, because there are many different nuances. So one is it mutual or unilateral? Okay, so this is what the agreement that you have in front of you, the basic one, which you signed a version of that, a modified version of that, is called a unilateral non-disclosure agreement. And that means, unilateral means it's one, going in one direction, like a unicycle, and it's going in one direction, and I'm disclosing the information, and you promise not to disclose it. A multilateral agreement is going to be going in both directions. Okay? So that's, or it's called multilateral mutual.
When would you have disclosed?
Okay, so let's say we're going to go into business together, right? So I have business way, let's say I raise money for businesses, right? And you have a business, Maisha, you have a business idea, right? So you're going to disclose the business idea to me, but I'm also going to disclose to you how I raise money. You're going to get access to my lists of investors. And so I don't want you to disclose what you learned from me, and I don't want you don't want me to disclose what I learned from you, right? So that's called mutual. It's going in both directions. That's very common. Now, if you are signing, you want as much as possible to make your non-disclosure agreements going in one direction and make sure you're protected and don't offer anything to the other guy. That's the ideal. But it's not always possible. It's very often that it's mutual, that it's going in both directions. So Yeshua is a designer, of an engineer, right? So he's got things he doesn't want other people to disclose, but the clients don't want things to disclose that they're telling him about, right? So it's going in both directions, right? It could be in many different types of situations that could come up a mutual versus unilateral. Another example of things that might be covered in a non-disclosure agreement is...
So when would be the typical case, and you were using unilateral, when would be the typical, just a broad, from a high level, what's the...
Well, think about unilateral. Typical would be just this type of presentation, right? All the information is going in one direction. You're not really disclosing anything to me as a presenter. I want to be protected. You don't have anything that needs to be protected in this interaction. Now, if we were each of you were going to get up and have a present, tell me about your idea, right? And I was going to give you feedback on the idea, that you would want to be protected, make it mutual. So anytime people are going into either there's mutual exchange of information, two-way street, or you're going in parallel, you're going to go into business together. So let's say a university wants to license or you're going to license from a university technology, that could be mutual. Or you're bringing someone on board, an employee. So that would be unilateral. He's not giving you any information. You're giving him the information. That's one-way street. So those are different scenarios where you can have one-way or two-way. Good question. Another thing is customer information. So customer information that's really critical, and especially in sales businesses. You know, who are the customers of the companies? Who are my clients, customers, and so forth? People don't want to let that information out. But in the process of working with other people, you're going to discover that information. So you want to make sure that's protected, especially when it's your information that's going out, who your customers are. It's not just the technical know-how. It's not just the secret recipe, which we'll get to the secret recipes in a few minutes. So there's something else called trade secrets. And trade secrets is something that is so secretive that you won't even patent it. Okay, so patents is a general concept where you have an idea. It could be a business method or a mechanical idea. It could be something where you know how something's going to operate or a chemical formula, and you're going to patent that. But what happens is when you patent it, it becomes public information. Anything in a patent becomes public, and everywhere in the world they could read your patent. So what happens if you cannot afford to let anyone know what what's in your idea? So the famous example of a trade secret is Coca-Cola. They have this secret ingredient, which no one knows what it is except 2 or 3 people and the Rabbi Machshir, the OU. And that's why Rabbi Marla, Olav Shalom, wouldn't drink Coca-Cola. Not because there's any necessity, it could be perfectly fine, but because he didn't know what the ingredient is. So how could you possibly, if you don't know what the ingredient is and they won't tell you, how could you rely on it? So that's a trade secret.
Why did they get the action?
So they were willing to give the OU, the Rabbi Machshir, one person at the OU to let him know what the ingredient is. I mean, yeah, and they also he gives a hechsher in Israel. So that's a trade secret. It's so closely guarded. The people on the front lines of Coca-Cola have no idea what it is. And to be a trade secret, you have to take measures to protect it. Now, why this is important in the context of a non-disclosure agreement is if you have a true trade secret, your ability to protect it is going to be dependent on how well and how hard you work to protect it. Okay? So if you give it out willy-nilly and disclose it without non-disclosure agreements, it's no longer a trade secret. If it's the kind of thing that's going to be in a safe, the formula or the technique is in a safe where very few people know about it, then if you're bringing anyone into your business, then you want to make sure that they're signing all kinds of non-disclosure agreements. And again, there's an example where you'd pay any amount of money to have a proper enforceable agreement signed. And one of the things we're going to get to, time permitting, is the question of enforceability. How enforceable is a non-disclosure agreement? We're talking about best case scenario. We're going to, discuss all these ideas and how to write the perfect one and all this kind of responsibility that we're going to take to protect this. But the question is, what could go wrong in court? Because it's only worth what you're going to be able to do in court later on. And then there comes issues of how long is it for, geography, what's covered, are there exceptions for it, is it under a court order, is the FBI demanding the documents? There's a lot of different reasons why the NDA could come crumbling down. Next thing I want to talk about is secret recipes. So I have a client. They're in a,
Is that what it's called? Do you guys call it in like
what?
legal jargon? You
Secret
call it
recipe?
Secret recipe?
Well,
Or is there
no,
a
it's
legal
not. This
name
is
for
just
it?
no. Well, trade secrets. Trade secret is the
If
legal
it's
name.
trade secrets,
Right.
it's legal.
Legal name. But I want to talk about recipes. It's a perfect example. When
You
you
said
have,
some trade secrets, they become public, when you patent them, then it's public information.
yeah, well, patent is not a trade secret.
Okay.
When you have a trade secret, you do not file a patent,
Okay.
even though it's patentable. Even though you could file a patent, but you won't because you don't want it to get out there.
Is there a certain type of patent, correct me if I'm wrong, that maintains secret confidentiality to some aspects of it?
No, a patent is published.
So there's no,
By definition, it's published because then no one's on notice that you have it. You have to give people
Someone
notice.
figured out the Coca-Cola recipe that they could have a patent against them.
Right, but Coca-Cola never filed a patent.
No, but I'm saying if someone figured it out.
Oh, if you figured it out on your own and you didn't, if you
I'm
didn't,
sorry, you didn't patent it. Like,
and if you find a Coca-Cola user, can you sue Coke?
yeah, you could, but then it gets complicated because then you have to come into court and tell the court your trade secret and how they're violating your trade secret. Now it becomes public information, and even if you try to seal it, now you have all these court officers that know it, and who says it's really going to stay
But
sealed?
my question is, isn't it wiser for them to? Obviously, it isn't. But
Coca-Cola?
What's the theory of? Wouldn't it be wiser for them, in theory, for them to have patented so that now they're ironclad and no one could go and?
No, there's no such thing as ironclad, and I'll digress slightly for this China issue because I had a friend. He's raising money for companies, and he was telling me about a business deal he was working on for a Canadian mining manufacturer. What they do is manufacture mining equipment. Okay, so these are like drill pieces that cost $350,000 each unit, and this fellow, this friend of mine, was telling me this Canadian company got an order from a Chinese company called I don't know what it's called, but they wanted 29 of these units. Now that's a great order. I mean, people usually only order 1, 2, 3, right? 29 units at $350,000 a pop. That's payday for this company. So how it worked was the negotiations went like we want 29, and the negotiating and get to filling out the purchase order. Actually, we only need 15. We only need 14. We only need 12. By the time the negotiations were over, they really only needed 1. So my friend is telling me this is going on. I said, you have to tell your Canadian clients that under no circumstances could you sell this 1 unit to the Chinese, because they're buying 1 in order to get their hands on it to reverse engineer it. And once they reverse engineer it, there's no way to stop them from producing it. Because all these NDAs are effective, if they're effective, in the United States, in US courts. But you're not going to be able to enforce this in a Chinese court. And you're not going to be able to, you might be able to stop the product from coming into the United States if you contact the Customs and Border Protection, but if they are able to catch it in the containers, but you're not going to be able to stop it from being sold in every other country in the world. And so this is a real issue today because you do have these marketplaces that are not using fair competition. And you're producing stuff in factories in China. I don't know last time I bought an air conditioner, but I have a few air conditioners of different makes in my house. And I picked up the wrong remote control one time, and it worked on the other one because they all work. The remote controls are interchangeable because all the ACs are made in the same factory. Well, no matter who the company is, they're pretty much all made in one factory that makes all the ACs. And so any technology, and what these companies do, this is a digression, but what they do is you come in as a name brand and you order your product, and of course they just see all your plans, and then they turn around and they make the knockoffs in the same plant when they're not running for you. They make the knockoffs that are now your competition. So really, if you have a really sophisticated product, you have to take that into consideration. How do you control the lines of production? Especially if you're offshore, you've got to choose reliable producers. That's why the United States is still the high-end products. You still go to the United States. More reliable countries like Taiwan, South Korea, where they have court systems, they have people that are more reliable, and you can protect yourself better. So anyways, this client has the secret recipe for this certain kosher product, which I cannot discuss what it is, but a very unusual kosher product, and they have this secret recipe. And there's not many people there's basically no one in the world knows this product or how to do it. And so they were hiring an employee, and we had to work into this consultation agreement a very, very detailed non-disclosure agreement and non-compete. And he will not. And we made it worldwide, and we had to write a whole description why this is a unique product in the entire world, and the competitive marketplace is very small. And if this person was to reveal it to anybody or to compete, it would severely damage our clients. So that's an example of something where you have to really put a lot of time and effort into non-disclosure. Another thing I want to bring out about the non-disclosure agreements, and then we'll go into the details, the nitty-gritty. So you have a standalone non-disclosure agreement, which is what you have a sample of here, and which you signed before. And then you have non-disclosure agreements that are part of another agreement. They're subsumed within another agreement. So for example, you might have a software licensing agreement that has a non-disclosure confidentiality piece to it. You could have a consulting agreement, partnership agreements, a development agreement for real estate, joint ventures, technology agreements with universities. These all have within them non-disclosure sections. Okay? So the question is timing. So what generally happens is you have a non-disclosure agreement that is then up front before you have any discussions. We're going to discuss an idea. And then you sign a framework for your discussions, the introduction of the idea. And then when you sign your formal agreement, which is much longer, that could be 20, 30, 50, 100 pages depending on what type of deal it is, you are going to have this non-disclosure agreement worked into it. And then there's some other terms I want to define. So you have non-disclosure, you have non-compete, and these are all found often in similar agreements. Now the key is an agreement is not necessarily what it's titled. So you'll often see non-disclosure agreement across the top, but what it really is much more than that. Or it might say that it's a lot of things at the top, but someone somewhere along the way cut out certain portions, and it's now no longer what it says it is. So that's really important. You've really got to read the agreements and make sure you have a lawyer that's reading the agreements. And what we do for our clients is that when we read an agreement, we explain the agreement to our clients, and we explain like in 4 tiers of explanations. This is a deal breaker. You cannot sign this agreement if this is in here. This is very important, and this should be fixed, but if it doesn't get fixed, it's not a deal breaker. And you want to get an attorney that's going to really explain it to you, because we get very busy, and these things take a lot of thought process about all the nuances. What's at stake? Like, what's at stake? Who are we concerned about here? Where is the risk? What could go wrong? And that needs to be thought through, and you've got to make sure your attorney's on top of it. So the more you can take out of this presentation to understand yourself what to look at, it's wise to read it yourself, and then ask about the things you don't understand. If it doesn't make sense, and often it could be grammatical errors. The sentences are contradictory. If you have 2 neverthelesses after each other, it doesn't make them 2. It's a double negative. It gets totally confusing. Yes.
Is there ever an issue with trusting a lawyer?
Sure.
You go to a lawyer, you tell them, and then.
Well, you have to.
I have this idea, blah, 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 and you sit down for an hour, you talk to him, and he says, I'm too busy, I can't help you, and then he turns. Is there
you have to. Yeah, you have to. I mean, I don't want to say anything against anyone in the legal profession, because generally very honorable people. I think it's an honorable profession. At the same time, you do have to be careful who you're talking to, and especially when you get to these companies, patent companies. They develop ideas. They say they're going to patent your idea. They're going to find you customers. They're going to find you marketplaces and investors and all that kind of stuff. You have to be very careful, because they're dealing in very parallel ideas, very similar ideas. They're dealing with your competitors, and you don't know unless you really know them to have a track record. Then you have to be really careful. Also with attorneys, you have to be careful with attorneys. I have a client. I can't say what they do, because it's a well-known company, but they had a product. Just as an example, I mean, attorneys make mistakes. They had a product, and they went to a top-notch copyright lawyer, and they had a product that was violating the copyright. So let's say this picture over here, the second one over there, because I can't see that one, it's got too much light on it. But the second one, so someone sends them a notice, that's a violation of our copyright. So this top-notch copyright lawyer is negotiating with him, and he says, well, our clients also have another one that's in violation. And he'd let them know about another point, another product that was in violation. And my clients were like, could not believe this. The guy said something so foolish. Like, yeah, you want to develop a friendly relationship with the attorneys on the other side, but you don't tell them where else your client is violating the copyright. You know, you just got to be careful. You got to be careful who you're dealing with as an attorney. You also have to be careful what information you're giving them, because I tell my clients, you know, you've got to make sure that you tell me everything I need to know. But in this case, I don't know, it was a good idea for my client to tell the attorney what other violating products they had, because he let it slip. So you have to be careful. You have to be careful, and if something doesn't strike you right, you have to ask questions, and then you have to move with your feet. You know.
So when the lawyer develops an NDA, do you also have the lawyer sign the NDA?
No.
It depends.
Well, I'll give you an example. So we're working on a real estate deal right now for it's $1 billion deal in Manhattan, and so there's investors, potential overseas investors coming in. So there's a lawyer, a foreign lawyer, who represents those investors. So we had him sign the NDA first, and then he's reviewing the materials to decide if he's going to pass them on to his clients, and then he's going to have his clients sign them. Now, there's a possibility that he won't have his clients sign them, but my clients feel, and the other people in the deal feel, that he's an attorney, he's already bound, and whoever he shows it to is kind of covered in it, not in a necessarily enforceable way that we can go after those people, but he has more at stake as a lawyer. So if you're giving information to a lawyer outside the strict scope of a legal arrangement, a lawyer-client relationship, then you definitely might want to have an NDA signed. That's what we did in this case. And we'll come to that later on if we have time to talk about when you sign NDAs, when the NDAs don't get signed, and you have to know how to use them. It's part of your arsenal, but it's not necessarily the only game in town. And I'll tell you a few stories about that. So we have non-compete. That means you can't take non-disclosure. Just means they can't tell anyone about it. Doesn't mean they can't compete with you.
Can you build a non-compete into an NDA?
Yeah. Well, ideally you would call it non-disclosure, non-compete, and then you would have a paragraph that says that you will not compete. So you could combine all these at once.
How can you prove that you tell what it does?
Oh, how can you prove? Well, that's a great question when it comes to court, but there's usually some sort of paper trail or witnesses. When it's overseas, it's a little bit more difficult.
So can you just define exactly what
But I want to take you an example. I have another client. He's an investor in a manufacturer, and I just heard this case a few weeks ago. This guy makes a product, and he sells it online. And you basically roll out all your products, like 100 products at the beginning of the year, and he put up all these pictures of all these products that his manufacturer in China was going to produce. So he gets this lawsuit in Tennessee, and it turns out what had happened is that there was a bigger manufacturer that manufactured all these products, and one of the designers in China who did all the diagrams and all the designers, he decided he wanted to make more money. So he went and sold it to this smaller company. And this smaller company had no idea. He says, these are all original designs. They're all original products. But they were the exact same designs, because my client posted the designs, all the blueprints of these products. Anyways, there's an example that the designer, it wasn't with the permission of the manufacturer, it wasn't of the company that actually had the plant in China. He was the guy who did all the diagrams for all these products. And he just sold them all to this smaller competitor. And now this competitor was hit with this massive lawsuit in the federal court in Tennessee and had to defend it. And it was a very disturbing story. So again, there's another story to show you that you have to be so careful. And it's also, there's only so much you could do to protect yourself, because there's all these people along the way that you can't control them from doing something. There's no this, but how do you find out? So okay, so you asked how do you find out, right? So how did he find out? Because these big companies, they go around the internet and they look at their competitors, and if they see the same diagrams, the same plans. There was one time a postcard published printed somewhere. It had plans of some top secret United States Air Force plane that was under development, and someone had stolen the blueprints and thought it was a joke and printed a postcard. And now they were selling postcards with the blueprints for this. So information, but once it gets out, there's a very good chance that someone's going to find out. Because the people, if it's serious business, people are going to look for it. All these companies, like the big players, they have people that are watching the internet every day. They're watching Amazon every day. I have a client that sells closeout products, and he got a letter recently from. They found them selling on eBay some closeout products that they claim were counterfeit. Now he doesn't think they were counterfeit, but the point is that these people are out there. Investigators are all over the internet. They're ordering products. They're testing the products. They're checking for copyright violations. If you take a picture for your website from another website, there's a good chance that within a few years you're going to get a letter demanding between $3,000 and $6,000 for the use of that picture, because Getty Images and Masterfile and these companies, they have sophisticated computers that go through every single web page and look for their pictures, and they can identify it, and they can trace it, and they can tell you where you got it from. And if your web designer is not careful, you're going to be hit with a lawsuit.
Encrypted and
and they can also compare the images. I mean, even if it wasn't encrypted, they also have this. The technology is so sophisticated enough.
You shrunk it. What if you crop the image?
Doesn't make a difference. They could tell from the hand and the handshake that is their picture. So these are you have to realize what's at stake over here. So I make a point on my own website. I always make sure any pictures we're going to get, buy them. They're not that expensive. You can get them from great pictures for low rate, because it's not worth it. Okay, so that's the answer to the question. How do you find out? How do people find out the information was disclosed? Because it gets out there. Once the information is disclosed, especially if it's a hot idea, they're going to see. If you have a great idea for a new plant holder, you could be guaranteed you're going to see it in all the nurseries in 2 years. If someone steals it from you, and you're going to be, since you're in that industry, you're going to be walking into a nursery, and you're going to see this tree and the plant holder that you told them about, and then you're going to know it could only have come from you. Now you're going to get into a fight. He's going to claim he heard it from someone else. His brother-in-law invented it, and maybe it's true. Maybe it wasn't. Sometimes people have parallel ideas, but okay. So non-compete, you can't compete. Non-circumvention means, this is another important concept, that I'm going to introduce you to somebody, but I don't want to be cut out of the middle for my part in the deal. Okay, so let's take this real estate deal. So there's a real estate deal going down over here. Someone approached me with the deal. I have the connection to this guy who has the connection to the investors, right? So what's stopping the investors from cutting us all out and going straight to the guy who's putting the deal together, right? So generally speaking, in many industries, there's something called honor. People don't do that. You pay your fees, you pay your way. I was in a meeting once. It was quite admirable to see this. It was a guy. One person introduced someone for a company. It was an investor. He introduced the company, and he just said in front of everyone, "It says I'm going to pay you a finder's fee because you found me this company." The guy didn't ask for any money. He just said, "This is the way I do business. I'm going to pay you." So there's honorable people out there, but you always have to protect yourself. So that's what a non-circumvention agreement. Circumvent means to go around. So you want to make sure this is not competing, it's not disclosing, it's not going around you, bypassing you, that you're no longer a key person in this transaction. Same thing with your suppliers. So for example, you have a supplier in Finland that makes a certain component for your product, and you're going to be shipping that product to your manufacturer, and you want to make sure that you're not circumvented, that he goes and buys, or someone else finds out who that supplier is and buys it directly from them. So that's, again, non-circumvention. So, and the last one is non-solicitation. Non-solicitation means that when you're going to figure out who my customers are, you're not going to try to go get the business from them. Or I have a slate of investors, or I have a slate of companies, whatever it is, you're not going to solicit them to try to get them to do work with you. So the reason I'm bringing these up is because they all tie into the non-disclosure. Non-disclosure is not necessarily sufficient. You might need a non-compete, a non-circumvention, and a non-solicitation. Okay. The question is, if you don't have the money, am I saying don't do business because you don't have the money, as you can't afford a lawyer? Well, you have to deal with reality. If you don't have the money for the lawyer, see, I'm trying to address the person who says he doesn't need the lawyer, or why should I spend so much money? This is a simple agreement. if you really don't have the money for a lawyer, but at least recognize that you do need a lawyer, you'd be wise to pay a lawyer, but you just can't. So you're going to proceed with caution. And you're going to do the best you can under the circumstances. There are circumstances a person has an idea, and not everything goes wrong. You know, you have to take risks. And we're going to talk about situations where with a lawyer, drafting an NDA, the right move was to proceed without the NDA. So I'm not telling you if you don't have the money that you are unwise to do it without a lawyer. You've got to move your business ahead. Okay, so I'm here to help the business grow. I'm not in the business, sales prevention department or the business prevention department. We're here to help the business grow, and we have to do that under whatever the circumstances are. Well, some lawyers would do that, but some lawyers might. But it's also, depending on how far-fetched that equity proposition is, you're going to get you might as well give them a $10 bill.
I just want to clarify something. An NDA, it means that you can't talk about it, but if I don't talk about it, I just do it, I can do it. And it means we have to also sign a non-compete.
A non-disclosure agreement says you cannot disclose the information. That's the strict meaning of the non-disclosure. Yeah, theoretically. You have to read it carefully because sometimes there's non-compete language thrown into it. You will not use this information. But the strict meaning of non-disclosure is you will not disclose it.
And let's say this basic one, has the compete element in it?
We're going to go through that.
So those other three, compete, circumvent, and solicit, are the other main three aspects, or there's many more than just those?
Well, those are three of the main ones. There's nuances, but those are the three other, confidential. You could hear non-disclosure called a confidentiality agreement. It's another term. Okay.
Can I ask you?
Yes, sure.
Let's say I have an idea, and I need to bring an NDA by multiple people. I think you even slightly touched it. Say I have to bring it by a software engineer, partners, consulting agencies, and I don't want to have to write an NDA for every one of these. Is there one that can sort of fit all of those?
Yes, so you could, if once you understand your business and what you're trying to protect, then you could develop a form for your own business and then apply in multiple circumstances. So it could be with different parties, different slightly nuanced differences, or you might have multiple situations. For example, we have clients that are a wealth advisory firm from Latin America. So we have a non-disclosure agreement for their employees and for the banks that they do business for, that they can't disclose their trading strategies. So everyone signs the same non-disclosure agreement. It's modified for the banks. There's a version for the banks. There's a version for the
It's a minor difference in a word.
salespeople. Right.
It's
It's the same general concept. And yeah. Okay. This non-disclosure agreement. Okay, the agreement. So I'm going to tell you a little bit of basic contract things for those of you that are not familiar, but there's a lot to learn about contracts. But this is called defined terms. So whenever you see something in parentheses with quotation marks, that's called a defined term. So now, from now on, we don't have to say non-disclosure agreement every time we want to refer to this piece of paper. We just call it the agreement. Okay? And the disclosing party is the person giving over the information, and the receiving party is the person getting the information. Now, very important, first point of non-disclosure agreements, who are the parties? Right? That's critical. Now, let's talk about you protect. We could talk in both directions here about which side you're on, but I'm going to focus that you have the information, you're going to give it to somebody. Okay? Now, when you have an idea, right? You're going to disclose it to me, as an example. Okay, so you're sitting down with me at the table, and I write my company's name here. That doesn't necessarily bind to me, right? It doesn't bind my business partners. I have some examples on the screen. I don't know if you have the PDFs available, but the point is that I have some non-disclosure agreements there that says this binds this company, its owners, its shareholders, its partners, its employees, its directors, its members in case it's an LLC and not a incorporation, its advisors, its lawyers, accountants. You can go on and define a whole world of people that are going to come in contact with this information or involved in the business. Its consultants. You want to make it as broad as possible. Okay, so
how is that binding to it if the shareholders, the accountant isn't sign the agreement.
Okay, so in one sense it's not, and the other sense it is. Meaning to say like this. Yes, the shareholder could say, I didn't sign it. But if he received the information in his capacity as a shareholder for that corporation, then he's bound, he has a duty to the corporation. And he's bound by the corporation, he has a fiduciary duty, and a duty of loyalty to the corporation. So he's violating the corporation's undertaking not to disclose the information. So you could get him in a sort of a derivative way.
He has to know about it, though? He has to be told.
Well, so in the non-disclosure agreement, you would say that you would want to mark everything confidential, or define everything as confidential, and say that anyone who's going to receive the information has to sign off on it. An intelligent, let's say, is being presented to the board of a corporation, this idea, then an intelligent presenter would say this is all subject to a non-disclosure agreement. Is it possible that they don't know? Well, it would be irresponsible internally for them not to say that, because we're going to sue the company for all those people that were named that disclosed the information, because the company had the duty to protect it. You see, we can't necessarily, might name the shareholder or the director as a defendant also, but to try to increase the pressure on them. But we've definitely got the corporation, because the corporation had a duty to make sure that this circle of people.
But the shareholder had personal responsibility for his liability?
Yeah, well, he might have personal responsibility, yeah.
If he didn't sign any sort of agreement?
Well, yeah, because the shareholder doesn't have responsibility for the debts of the corporation. But some of them does have responsibility, but like payroll and taxes and environmental issues and so forth. But we would argue, and a court might not agree with us, but if we were on the side of the prosecuting, so the plaintiff side, we would say we want to try to nail everyone who had any association with this disclosure of information, and let them try to get themselves out of the mess. Because you, as a plaintiff, you want to cast the widest net possible, and you want to write the agreement in the widest way possible to cover everyone. Now, if you're writing an agreement to a single guy who's, you've got to have some sense about the context here, right? If you're writing, it's another guy that's, you're a single person, sole proprietorship, and you're writing an agreement with another guy who's a sole proprietorship, writing about his directors, shareholders. I mean, it's called overkill, right? So you've got to use, this is a really context-sensitive document. Okay.
How would you say you were talking to a consultant it's just him, he's barely even a company, he's just an advisor, and you speak to him, how would you broaden that? He doesn't. Okay, great question. So how do you broaden it if you have an individual? So usually individuals have an LLC. Let's say he's a consultant. He might have an LLC. So I would put in the LLC and and him, and then I would say that this is binding on all other consultants and anyone else who works for him. Because he might get so busy that he hires another consultant and brings them in. And before you know it, he's got more employees. Right now it's just one guy. But if you're giving him some good business, then he might grow, and now he has other people staffing this project. Let's say he's a college student. There's no LLC. Is there anywhere for you to create an NDA there? He doesn't just go yakking.
Well, yeah, to create it, he can't tell anyone. But if he hires he subcontracts. A big issue is subcontractors.
Right.
Okay? So leaving aside LLCs, you want to protect it. He has to get any subcontractors to sign the same non-disclosure agreement. And you could put in there, he can't have any subcontractors unless you approve them. Because you don't want him subcontracting this to India or China, and you can't protect it. So it's not just the non-disclosure part. You want to control whose hands and who's involved in this project. You want to have the right to vet anyone who's going to come into this project.
Isn't there a thing about having a non-disclosure or non-compete that's too wide?
Yeah, we're going to get to that. That's enforceability. Whereas, so sometimes there's whereas clauses. This agreement doesn't have it. Watch out for whereas clauses. They're not legally binding in the sense that they don't state an obligation, but they usually state some context or history or purpose of the agreement, and you have to make sure that they're accurate, because it could throw off a court or a jury later on who's reading it, and it misdescribes the relationship or the role of the parties. And like, for example, you would want to put in a whereas the information being disclosed is highly confidential and in a highly competitive industry. You might want to make that kind of broad statement at the beginning so that you could tell the judge later on, well, we only entered into this agreement because we got this non-disclosure signed. Definitions. So really important. There could be a definition section. And the first one here is definition of confidential information.
Can where I work against you, where if you say it's a very competitive industry, can they argue, hey, it wasn't really that competitive, and therefore the whole thing, it shouldn't be decided?
Yeah, you have to be careful what you're, yeah, absolutely. You've got to read it with a fine eye to understanding. You know, one thing I was blessed with is that my legal career started with both litigation and corporate work. So when my first day in court was arguing an appeal before the Federal Second Circuit Court of Appeals in New York City, in Manhattan. And so my whole legal career, I understand how things get litigated, and I understand when I'm doing litigation, I understand how the contracts are written. So most lawyers really have experience only in one of the two. But when I read a contract, I'm thinking, how could this whereas or these words be construed later on in front of a jury or in front of a judge to mean something else that we don't want it to mean? And that's why it takes so much time to write these agreements properly. And I saw a case litigated that we took on appeal twice, where it was literally 4 years of litigation, almost $500,000 in legal fees over a semicolon. Where the semicolon was placed and what the clause after the semicolon meant and who intended what, and it really happens. So definition of confidential information. So that's really critical. That's your first starting point of saying what's confidential. Now notice over here in this agreement that we're using as a sample, it says, if the confidential information is in written form, the disclosing party shall label or stamp the materials with the word confidential or some similar warning. This is really critical if you're the disclosing party. Because what happens if you forget to stamp it as confidential?
Stamp what?
Whatever you're giving. Here's the plans, right? Here's the idea. And you forget to stamp it. So this document, you could have a lawyer write it, you could do all the good things, and if you forget later on to stamp some piece of paper as confidential, it's all out the window. It's no longer confidential information. And if you read further, it says, if confidential information is transmitted orally, the disclosing party shall promptly provide a writing indicating that such oral communication constituted confidential information. So here you are, you had this thing signed, and then you sit down, okay, here's my idea. You tell the guy your brilliant idea, and you forget to tell him in writing afterwards that it's confidential. You could tell him, this is my brilliant confidential information. We got to close all the windows and close the shades, make sure no one ever hears this, make sure no recording devices here. Here's the idea. And then it says here, if you didn't put it in writing afterwards as confidential, it's not covered as confidential information.
Or do it an hour later, it's not promptly.
Yeah, and they could argue how promptly it is.
Presenting it orally, repeat my question. Then what do you write as confidential? You write down the word.
No, you say, I met with you half an hour ago, and I told you my brilliant idea, and it's confidential. You're not going to put the right idea in writing because you don't want it necessarily in writing. But here,
Separate contract for that, or just do it on this paper?
no, it's just a note. It's some sort of notification that it's confidential.
attached with this. You have a second piece of paper.
Well, that could be an addendum. That could be an addendum, but this doesn't refer to addendum here. It doesn't say the information on Schedule A.
It shall properly provide a writing indicating. So they have to sign this first, and then I tell you my idea, and I write down that you heard my idea at this time. These two have to be together.
They don't have to be together. Not necessarily. If it says the information, if the information says whatever, if this says whatever's on Schedule A, then Schedule A would be attached. But it doesn't require it to be attached. What it requires is that after you sign this, I give you the confidential information. I have to send you a writing that says we discussed the confidential idea.
But how would you be able to sue that? Because if there's no recording, and I tell you my idea, and you go out to do it.
Okay, so that's,
I told you what I
well,
thought.
because you probably have, or hopefully have somewhere in your secret files, this idea mapped out. And you could show that you date it, and you have your computer files, what date you first drew this CAD diagram or whatever it is. And then you now go to court and say, look, this is, well, that's the problem with suing on these things, if it's truly that secretive. Now, at some point, sometimes the best blessing someone could give you is to go steal your idea. Because then you get to sue them and get the money for your idea without having had to do the work to sell the product.
Only solidity.
So but the key over here is about the confidential information. So if I was drafting, if I was the disclosure, representing the disclosing party, I would scratch out all this information. I would say, any information we provide on this subject is by definition confidential, whether oral or written, and no further indication or labeling is required. Because I don't want my client to have to worry about, is every page stamped? Did his secretary forget to stamp this? Was there some sudden communication idea, an addendum, an additional idea, some developed thing? No. So that's why I would change it. Now, next, in the discussion of what? The definitions, right? So the next thing is paragraph 2. After we went to this definition, which is basically, and by the way, all material or all information or material that, and would be paragraph 1. All information or material that has or could have commercial value or other utility in the business in which disclosing party is engaged. You might want to work on that, because now it's a debate. Could it have commercial utility? Does it have commercial utility? You might want to change that. Number 2, exclusions from confidential information. Now, here's 4 things. After we define confidential information, there's 4 things that, by definition in this agreement, cannot be confidential. Okay? So number 1 is, it was publicly known at the time of the disclosure, or became known later on for no fault of the receiving party. So let's say someone else puts online the secret recipe of my client. That's now public information. It's no longer confidential. B, discovered or created by the receiving party before disclosure by the disclosing party. C, learned by the receiving party through legitimate means other than from the disclosing party. Or D, is disclosed by the receiving party with disclosing parties, a receiving party with disclosing parties prior written approval. And sometimes it says an exception to the obligations is by court order. So I'll just tell you a few quick pointers over here, because we could go on for more time, but I'm willing to do it, but it depends on you and everyone else's other commitments. But this is really critical. Now, if I was writing this in a really significant matter, I would want to change it so that I don't care if you found out the information from a public source. If I'm letting you in on my way of doing it, then this is a special relationship. I don't care if you find it in some Wikipedia article in some paragraph. This is whatever I'm disclosing, you cannot, especially when it comes to non-compete, right? Because there's the non-disclosure, so it's true that he could repeat the information because he could just point to the paragraph in the Wikipedia article. But I still don't want him to compete with me, because I told him much more than that piece of information. I let him know about my business plans. I let him know that I'm seriously contemplating. Maybe he knows about the weaknesses in the business idea, where the stuck points are, and now he could really go and compete because he knows that there's real limitations in this. Because here's one point, because there's so much to cover, but you have to understand that when you're developing a business, there's not just the brilliant ideas, there's the ability to implement it and deliver it. And one thing you have to remember is in all this discussion about non-disclosure agreements, this idea is not going anywhere unless you can get it to go somewhere. And that is a really critical piece of information, critical context. So some people go to the opposite extreme. Some people are like, here's my idea, and people walk away with it. And other people are just super, super secretive. They won't tell anyone. I had a client that he went into a business partnership with a guy who developed an oil additive, okay? And it was, the scientist was like, talk about the mad scientist. He wouldn't tell anyone about the secret formula for this oil additive. It was so secretive he couldn't develop the business because he wouldn't tell anyone how to manufacture it. He would make it in his garage, okay? So she was laughing because I'm sure he's met people like that.
The oil guy, the fried, the French fry guy?
No, it was for your car. Fuel, yeah. So, so you have to think about that. How am I going to get my business? So someone said to me, a wise person I learned a lot from. He's very successful in business and developing relationships, and he said, you have to be willing to share a little bit about your ideas, because you're going to meet the people that can help you move your business forward by disclosing enough information that someone will say, oh, that's interesting to me, I'd like to work with you on that. Or, I know someone who could help you move that forward. If you're too secretive, you could really be closing yourself off from a world of opportunities. And the truth is, no man is an island. None of us could really move ahead our ideas alone. So, you want to stop now?
Knock it off.
Okay.
We did start a little late.
I'm fine. I'm not. I just want to respect the organizer and everyone else. Okay, obligations to the receiving party. So this is where, in the experiment I sent around, this is where you guys signed away all your rights to all your future proceeds, and spiritual and physical, from anything you ever do. You've got to be really careful. What are your obligations? What level of secrecy do you have to keep? Sometimes it's, are you going to require the other person to keep it top secret? Or is it going to be with best efforts? Is it going to be with the same care that he keeps his only confidential information, which means for some people no care? Okay? Like you're going to bind someone to keep your information with the same standard that he uses for his own. Like what does that mean? That you see them on NDAs all the time. Will use the same standard of care as he does for information. That means that's meaningless. Some people leave their piles of papers out on the desk and they share office space with other people. A guy who's using a Regis office and he shares it with 3 other people, that's not very confidential. Or a WeWork space, you know? They don't have locked doors there. That's beautiful, but what does that mean? Okay. There's also obligations to return the information once they're finished with it. These are all very, very important points. Another point that's not brought up in here, but issue with court orders and subpoenas. Okay, this is a huge issue, but people don't really pay attention to it. So the court says you have to, they have to disclose the information. It usually says that they have to keep it confidential unless subject to a court order or subpoena. I always put in, when I'm representing the disclosing party, that you cannot respond to the subpoena or the court order. I don't care who it comes to your door, if it's the FBI or the NSA, whatever it is. You have to give us notice that we can go to court to try to object to that order. Some people won't give you that, but that's what we always bargain for, is that we want the right to object, to go to court and try to prevent this from being disclosed. Okay, next issue. Time periods. How long does this apply for? So some agreements say 2 years. Some say 1 year. Some say, in this case, it says until the confidential information no longer qualifies as a trade secret. And the funny thing is, if you were reading this agreement carefully, which I'm sure you're now going to, but it doesn't say anywhere else in this agreement that it's a trade secret. It talked about confidential information, right? Now all of a sudden it threw in the word trade secret. Well, trade secret is a much higher standard than confidential information. So if you had someone sign this agreement that says the confidential information may no longer qualify as a trade secret on the day that he signed it. It may never have been a trade secret. You never asked that it has to be a trade secret up here. So here's an example of an agreement that you could buy for $10, and right from the outset it doesn't protect one single thing that you signed. And your lawyer could also, you have to read this carefully. What is no longer qualifies as a trade secret? Excuse me, sir. Call your attorney. What's a trade secret, and why is it suddenly appearing over here when we're talking about confidential information? Relationships. Great point over here. It usually says that we're not becoming joint venture partners, or employees. We want to clarify that in this agreement that it's just about disclosing this information. We don't want to allow it to blossom into some other relationship that is going to be leading us to much litigation, and then he claims, well, we're really partners, and that I told the information, now I have a right in all the proceeds, and so you want to keep that limited. Severability means, yeah, my agreement made me like a partner in your life forever, Okay, so severability is about saying that if there's what could happen is if one clause is wrong, the court could throw out the whole agreement. So what they want to say over here is that if one paragraph or one clause is wrong, the court could strike that and the rest stays in effect. Integration is sometimes also called merger. Merger means not that you're merging companies. It means that this agreement is the sole agreement between the parties. Everything we talked about before and after doesn't apply. Like if you sign this agreement and say, well, I don't really mean this, right? That wouldn't mean, because it says here that anything I say orally has no effect. It's only what's in this agreement. That's called integration or merger. So you want to be aware that's really important. Get clients all the time, but he said that. But he said that means nothing. Okay? It just means he said it, but the agreement says that it supersedes all prior proposals, agreements, representations, understandings. Plus, it can't be amended unless it's in writing. Waiver is saying that, usually it's saying that just because you don't enforce some right, it doesn't mean you waived all your rights. Now, a few other points that are not brought up over here. Critical points that are missing from this agreement. Who can tell me something that's missing? Okay, well, you don't know because jurisdiction. What court are you going to be sued in? Oh, that's one thing I wanted to put in my sample. I forgot this, the experiment. I wanted to put in that, you know, any litigation was going to take place in Seattle, Washington, right? Or, you know, the popular jurisdiction is Singapore, right? Because they're only reliable courts in that area of the world.
What's the deal with Singapore? Isn't that through Catholics or something?
Well, Singapore, no, because it's a stable country, and they have an English legal system. So,
English or British?
yeah, I mean, they're a stable British country, you know, a formerly British country. So people choose it as a jurisdiction. London is a popular court. New York, Delaware, these are popular international courts. Singapore is a popular court. But the point is, it doesn't say whether this is going to be sued. Now, you've got to be very careful. I had a client. He was going to look at a company, to buy a company in North Carolina, and they wanted to have, on the NDA, North Carolina jurisdiction. So I said to my client, there's no way that you're going to sign an agreement that you're going to go to North Carolina to defend yourself, because if you're receiving the information, you're the one who's likely to be sued, right? So you got to be very careful. And then also, if you're the one giving the information, where are you going to have to chase this person down and sue them, right? So Singapore, you're not going to Singapore so fast, no matter how valuable your idea is.
But have you come to an agreement with
Well,
sides in different state or country?
You try to tell them, listen, it's called balance of power. Who has the bargaining power, right? If you have the idea and they really want the idea, then you tell them it's going to be in my home jurisdiction, or we'll find a neutral jurisdiction like, let's say, Delaware or something like that. Sometime popular. Although there's issues whether you could, depending on which federal or state court, whether you could choose a jurisdiction, a venue that no one resides in. So it's not necessarily a slam dunk. But the point is, you got to watch out for. So that's a great point, Yeshua. Another thing that's missing is applicable law. This does not say which state law or country's laws applies to this agreement. Every state is different. In California, you can't have a non-compete agreement for employees. You cannot tell the guys in Apple that they can't go work for Google, even though they try to do it privately behind the scenes. But that agreement would be unenforceable in California. So which state is this going to be, what state law? Another question is jury trials. Sometimes in the agreements they try to get you to waive jury trials. You have to think about what that means to you. Sometimes they try to put arbitration in. Who's going to be the arbitrators? There's not the time to discuss the choice between jury and trials and non-jury trials and arbitration versus litigation. But these are significant issues, and it makes a big difference which side of the table you're on, what you want. Sometimes they also have, that's a good point, and I appreciate you bringing that up. An injunction means you go to court and say, Judge, this guy's damaging me. Before we get to it's a rush. We got to have him stopped right now. He's competing. He's stealing information. Whatever it is. Some agreements will give them a right to an injunction. Be very careful if you're on the receiving end. There might be liquidated damages, which means that they set out at the outset what the amount of money is going to be in damages. Okay, assignment. Can this agreement be assigned to someone else? Let's say this. You disclose the money to the receiving party, Crown Heights Youth Entrepreneurs, Young Entrepreneurs, right? And you really like Yeshua, and Yeshua decides to sell the company to Empire Kosher, right? And now Empire Kosher has all your information, right? Do you want Empire Kosher to have your information? I don't know, but probably not because there's anything wrong with Empire Kosher, but you went into business. You decided to disclose the information to Yeshua.
If they sign this, wouldn't the agreement now be?
Yeah, but you vetted Yeshua as reliable. You didn't vet Empire Kosher, so you want to have a non-assignment clause.
It's like that subcontract.
Well, it's simple. It's an assignment. Also, what happens if the company's bought out? Mergers. What's going to happen with the information then? Assumption.
Is it called a non-assignment clause?
Yeah, non-assignment clause. Now, there's also something called an assumption clause, which means that if it is assigned, then whoever it's assigned to assumes all these obligations. Signatures. Okay, biggest mistake clients make, they paid all the money. That was a good choice to pay a lawyer to do the agreement and then negotiate it. The biggest mistake they make is they don't get it signed. They don't sign the agreement, or they don't make sure the other person signed the agreement. Now, that is a huge problem. I mean, I can't tell you how many clients that later on they come to
That's
us.
like buying a car and just not knowing what a gas. Who does that?
People, it's just try signing agreements to see. You'll see. You cannot imagine how many people don't go ahead with fully signed agreements. I mean, even lawyers. Let's say we're representing 5 clients, right? So you send out the retainer agreement, and 3 guys sign the agreement and send it back. So they sent the money in, so we start working, right? Now we have to remember to get the other 2 guys to sign, but we're not. We got the money and a couple guys signed, so we're ready to go on the case. If they don't sign, then we can't collect the money from them for the case because they never signed, right? So we have to be sure to follow up.
It's because they forget to ask them at the meeting to sign
No,
them.
because people who don't want to get bound by agreements don't sign them.
But then there's stuff isn't information anyway.
Yes, because you forgot. You thought it's in the mail. He's faxing it to you. There's a million reasons. Or let's say it has to be to 3 or 4 people. Let's say there's 3 or 4 people on the receiving side.
By always means the signature.
By is the that's the put the
And
signature.
the name always means the first name and last name.
Yes.
There never company name. Do you need that?
Well, there should be a company name. The company name should already. You should put a company name
So if you're
if it's a
presenting
company.
it, it's a good day to have a lawyer with you. If you have the finances to go and check, and you have to check the ones that
You have to.
make sure that
Yeah, I mean,
they are who they are.
usually you know who they are by the time you've been in the discussion that long. Now that's kind of the contextual point. You know, you're not going to ask someone. I'm not going to ask Yeshua for an ID before he signs an agreement because I know him. I know who he is. Like it would be kind of ridiculous, right? But I didn't meet someone before. I might say, but if I'm already at this point of this agreement, I already know who they are. I've got a pretty sure. I wouldn't. I mean, you could do.
If you have lawyers present, they're most likely going to make sure everyone's signed before. They'll tell you don't start talking until we make sure.
Yes, but sometimes talking happens first. Okay, a few more points. Should I wrap this up? And I'll go through the last points. Okay, so number 1 on this agreement, dates. Now, did you notice over here on this page it has no date?
No, I'm saying just usually.
What does it say
no,
tonight?
it would be on the top.
Oh, it could be any. It could be the date, or today could be down here, or date for each signature. If there's no date, how are you going to prove?
They didn't get up working on your idea.
Right.
prior to your-
Right? Oh, we didn't sign that until June the 1st.
It is dated in yours. On the bottom it says dated.
Oh, but okay, so maybe yeah, you're right.
Make sure that they date
Good
it
point.
properly.
But did everyone date it when they signed this? No, this guy signed it over here, okay? I don't know who this is. Chaim. Chaim signed it. He didn't date it.
Do you also want so dated?
And he also signed over the disclosing party. Okay? So, we're passing papers around. No one's paying attention to all these details, right? So this is what happens. Now, I just want to finish with a few points here. This is where it gets into the nuances of relationships. Okay? So let's give an example. You go to someone's house for Shabbos, and you say, this is really delicious challah. Can I have the recipe? And they say to you, I'd be happy to give it to you. First, you have to sign an NDA. Okay? Is that an appropriate social interaction? Yes or no? Moshe, would you sign an NDA for the Shabbos challah recipe?
It's really good.
You mean on Shabbos or?
After Shabbos. They'll let you sign after Shabbos, but they won't give you the recipe. Okay. So, that's an example of, you got to use some seichel, some intelligent understanding. When's the right time to ask for non-disclosure agreements, okay? Now, also, what's worth protecting? So if I'm going to open a bakery to make mini cupcakes, okay, right? So there was someone here recently who used to have a bakery to make mini cupcakes. That's why it came up in my mind. But mini cupcakes, right? I mean, that's wonderful, but no one here is going to go make a competing bakery to make mini cupcakes. If I want to sit down and tell you about my ideas, it's not really worth getting an NDA from you for that. But if I have a great new technology that it really could be a game changer, then that would be worth doing an NDA for. So you have to use your thought process to figure out what's really worth it.
If you're going to go patent something, so one of the clauses in the patent is can't be common knowledge, which means you can't discuss it with other people. However, if you give 20 people and they sign non-disclosure, it is not considered
Common knowledge.
common knowledge.
Yeah.
But if they didn't sign, unless it's your spouse, if they didn't sign a non-compete, that's considered public.
So that's a factor in this idea. Is it patentable, not patentable? There's a lot of great ideas that could be very big money that are not patentable. Okay. Now,
Can you give an example?
so of something that you
Something
wouldn't.
that you can patent, but you would record, you'd try to get an NDA covered.
Well, cupcakes now, but let's say for example, this real estate deal. We had the guy sign a non-disclosure agreement. There's nothing patentable. It's just a business idea, you know.
I have one, but I can't disclose it.
An opportunity. Yeah, you don't want to disclose the opportunity. Okay, so let's talk about the give and take of business. So sometimes it's not possible to get an NDA signed. Okay, and there's some people who will never sign an NDA. If you have a great idea for a home product, Bed Bath & Beyond will never, ever, ever sign an NDA. And the reason they don't sign NDAs is because as soon as they sign the NDA, if they have any product that comes, they're going to be hit with 1 million lawsuits. So they will never sign an NDA. So don't even waste your time opposing it to them. Same with, we have a client. I'll give you an example. We have a client that invented a product. And we managed to get her into the CEO of the world's leading manufacturer of this line of products. And as good lawyers, we proposed an NDA. And a very comprehensive NDA. Well, this guy, hemmed and hawed, the CEO, hemmed and hawed. I'm talking about, he didn't even want to send it to a lawyer. He didn't want to pay for the legal fee. So he's trying to negotiate it himself with me, right? But he's talking about, well, I don't want to sign this because I might have something in production. He was very cautious about this because maybe he has this, he doesn't know what we have. Maybe he has this idea in production already. Anyways, at the end of the day, it kept getting stalled. He just would not sign. I kept making some changes. I tried to I listened carefully to what he said. I made changes. So the next thing I know is my client, who is a very down-to-earth, straightforward person, she sends this CEO a text message and she says, listen, we've got to meet about this product. And the next thing I know is we are sitting in this guy's office and we're presenting this product with no NDA. Now, she made a calculated judgment. He is the world's leading manufacturer. She's going to have an opportunity to present this idea to this fellow. And if she insists on the NDA, she's never going to get into his office. If she just forgets about the NDA, she has a couple things going for her. First of all, I went to the meeting with her. So we have witnesses that we disclosed this idea to him. Second of all, he said in the meeting,
Businesses help if you don't send an NDA. You never, you know what I mean?
okay, but if we had to go to court, I could say I was there, she was there, we told him this idea. He also said in the meeting, I have nothing like this under development or production. So now we have him making an oral statement. That's good for our side. The next thing is we have a patent pending, and we showed him the diagrams from the patent. So he says, I want to show this to my product development team.
Nice.
So I said, I understand you won't sign the NDA, but I'd like you to sign these diagrams that you received them. So he signed them. We made a copy, and he signed his signature on and the date, and wrote received that he signed these. So now, what does my client have? She has a discussion. She has an oral conversation, witnesses that he received the information and that he had nothing under production, plus a signature on the patent diagrams. Now, if that product comes out to market, we're gonna be able to prove that he got the idea from my client, right? So there's an example where the right thing to do was to ask for the NDA up front, but she made the right move when she saw that it wasn't forthcoming to go ahead with the deal anyways. And the end result is that we have it now situated that if, God forbid, he was ever to copy this idea, she'd be in a very strong position. She doesn't have an NDA, nothing in writing, but we could have a paper trail.
How do oral conversations, things like that, go down in court?
Well, that's a whole subject. We can make a lecture on that, the presentation itself. But there's all kinds of rules of evidence about what that means.
Did everyone find it was there to say that you were present, that she was present, so you had
that on the diagram on the.
Some people that says he saw the diagram, he signed the diagram.
No, but also no, because I have a signature on it. I don't need my signature on it. I have the original copy in my file now of his signature on these diagrams. He can't deny. I mean, he could say it was forged.
You as a witness, you could say if your signature's on there too, would it make it stronger?
Maybe, but I also have it in my calendar, and I could say in court I keep an accurate calendar, and she has it in her calendar. Okay. So I want to just finish on this point then about the Okay, so again, relative bargaining power. If you're trying to get the attention of someone who's very big and could make your deal fly, walking up to him and saying, I have a great idea for you, but first you have to send this NDA. It's just, he's going to not even pay attention. He's going to say, I'm sorry, I'm not interested, I don't have time for that. So you really have to work on be able to get it into a place that you could get that conversation going. And if that's really the person that could get your product or your deal going as far as you want it to go, then you might not want to stand on ceremony. Because the chances are, there's people who steal ideas, but most ideas don't work out because people didn't implement them. So your biggest chance of not succeeding in business is because you didn't implement your idea.
Not because you didn't get it.
Not because you didn't get it and someone stole it. So you've got now, if you're hiring someone, then the bargaining power is on your side. You could hire someone or a consultant or someone to do a programmer or an engineer or whoever is going to work for you, then you have the power. He wants the payment for the job. You can dictate any terms that you want as long as they're valid under the laws of the state that you are signing it under. But if it's not, then you have to really evaluate the situation and that give and take of business dealings. And I want to just finish on this point about the enforceability, which is that you also have to evaluate how enforceable the agreement is going to be. And these are very difficult to enforce because you have proof problems, you have liability problems. Do you have the right party who actually disclosed the information, assuming you could prove it? Do you have damages? What are your damages? So you had the great idea for the technology, and then the guy stole the idea. Well, you know, how much were you really damaged if you weren't able to get the idea out there anyways? There's a lot to enforceability. Can you get him into court? Will he come to court? Will he stop doing it even if the court tells him to stop? So the court orders him to stop his production. So he'll continue doing it overseas. And he'll sell it in the rest of the world. So you've got the one thing, I have a webinar that I did on contracts. And I started the whole webinar with the whole concept of, is this person someone you want to do business with? Because the contract could be very good, but it's not worthwhile. If the person's going to cheat you, then the agreement's not worth anything. Because to enforce an agreement is a tremendous amount of money. And I didn't mention to you, of course, you know, we're talking about $5,000 for maybe an NDA, $1,000. How much are you willing to spend for an NDA? Try litigation. Okay, you got all these grand ideas. How are you going to sue this guy now because he stole your ideas? To walk into court to get an injunction, $15,000. You want to do it out of state? $20,000, $25,000. You want to go into more litigation? You want to get into discovery and appeals? You're talking going into the hundreds of thousands of dollars, and especially if it's a worthwhile idea. So it really starts with using your own judgment about, is this a person I want to do business with? If you have any gut sense that I don't want to do business with this person, then don't. Because in the end, something's going to go wrong. And you can't afford to let your ideas get lost. So you've got to take all these factors into consideration when you're going into a non-disclosure agreement. And I know that you should have put in the ad, you know, why you must have a non-disclosure agreement. So the answer is, it's not always the case that you must have one, but it's something that you want to have in your quiver, in your arsenal of agreements, that you understand what it is, you know when to pull it out, you know how to get one, you know how to get one drafted, and you're then able to follow through, implement it properly, and understand the risks and how well protected you are. Don't just say I had an NDA signed and therefore everything's okay. You have to stay on top of it. You have to make sure that the person is really respecting the NDA. And first sign that anything is being disclosed, you've got to act on it. Like I said, vetting any future subcontractors. You've got to set up gates to make sure that everything is properly protected.